Warm greetings everyone. I am Dr. Pawandeep Kaur from Khalsa College of Law, Amritsar. The topic of our today's module is corruption in judiciary. Welcome all to today's talk. Dear students, this module will make you acquainted with the judicial corruption, how does corruption take place in judiciary, corruption in the Indian judiciary, causes of corruption in the Indian judiciary, regulatory mechanism to combat corruption in the judiciary, the key concerns and challenges of the in-house mechanism. Dear friends, before we start with today's talk, I would like to quote the statement given by Huguet Lebel, Chair of Transparency International, that equal treatment before the law is a pillar of democratic societies. So friends, when courts are corrupted by greed or political expediency, the scales of justice are tipped and ordinary people suffer. Judicial corruption means the voice of the innocent goes unheard, while the guilty act with impunity. Dear friends, the Indian judiciary, often hailed as a guardian of the Indian Constitution and the defender of justice, is not immune to corruption. The judiciary, meant to be the last bastion of hope for the common man seeking justice, has been marred by allegations of corruption and nepotism. This issue has been a cause of concern for citizens of India and has raised questions about the credibility and integrity of the judicial system. Corruption is one of the essential evils of the society, whereby each person gets himself influenced somehow by this evil system. Public life gets itself contaminated, amidst which citizens need to confront troubles, both social and financial. The corrupt individuals get their work done at the cost of the common man. In this way, the administration does not function properly, having no effectiveness, honestness in its exercises and group welfare activities being overshadowed. Corruption damages judicial systems and thousands of people worldwide are denied access to justice and protection of their rights. A well-functioning government with the citizens' best in mind requires not only the rule of law but also an independent judiciary that enforces the law impartially and equally. When the judiciary is corrupt, it facilitates corruption in other sectors of government and it transmits to the general public the message that corruption is accepted. Corruption in judiciary is a serious issue that can undermine the rule of law, erode public trust and compromise justice. It can manifest in various ways such as bribery, nepotism and abuse of power. The perception of corruption in the Indian judiciary is widespread, with over 45% of Indians holding this view, which is also supported by outside evaluations. In addition to being pervasive in the lower courts, some have claimed that corruption even exists at the highest levels. A former Supreme Court judge said in 2014 that 3 past Chief Justices of India made improper compromises to allow a corrupt High Court judges to remain in office, while a former law minister declared in 2010 that 8 of the 16 former Chief Justices of India were corrupt. Unfortunately, there is a tendency in the Indian judiciary to see any demand for more judicial accountability from the executive or legislature as an assault on the independence of the court. That worry is understandable given the brief history of power struggles between the 3 branches, but it seems implausible in the light of growing number of allegations of corruptions inside the judiciary. Corruption is as old as society. Corruption has become a way of life, an acceptable way of life, and judges don't drop from heaven. This was former Chief Justice Ranjan Gogai's reply when a journalist asked him about corruption in India's court. Such a statement may seem extraordinary coming from a former Chief Justice, but he is not alone in holding this belief. Two other former Chief Justices have acknowledged the pervasive corruption problem facing India's judiciary, particularly in the lower courts, where most Indians interact with the judicial system. This perception is backed up by quantitative evidence. According to Transparency International, 32% of Indians who used the courts in 2020 had paid a bribe that year, while 38% resorted to personal connections to navigate the system. Although Indian judges are not nearly as corrupt as Indian politicians, the Indian judiciary, like international counterparts, is dependent upon its reputation for impartiality, fairness and incorruptibility. A loss of public confidence is almost unaffordable for the courts. Therefore, it must have served as a wake-up call for the judiciary to encounter waning public support while it engaged in a legal battle with the executive and legislature over the National Judicial Accountability Commission Act, which aimed to increase the executive's influence over judicial appointments and increase their transparency. There was both tacit disbelief and outright criticism when the Supreme Court ultimately invalidated National Judicial Appointment Commission in October 2015, citing the need for complete judicial independence. Although the current appointment system in which judges appoint their successors has been relatively free of corruption allegations, the National Judicial Appointment Commission debate brought forth long simmering concerns of judicial corruption and worries that even judicial appointments was not above suspicions. Dear friends, further we will discuss the meaning of judicial corruption. Corruption is a form of dishonest or unethical conduct by a person entrusted with a position of authority, often to acquire personal benefit. Corruption may include many activities, including bribery and embezzlement. Judicial corruption is inimical to judicial independence and the constitutionally desired social order. Dear friends, the next important question is, how does corruption take place in the judiciary? Detecting corruption has always been a big problem. A non-corrupt judiciary is a fundamental condition for the approval of rule of law and the ability of guarantee basic human rights in society. The judiciary must therefore be an independent and fair body that fights corruption, not the other way round. Now the question is, are some of the judges bore to misuse of powers given to them in the temple of justice? Are they under the influence of political leaders and bureaucrats, etc., through illegal means because of which the judicial system has become corrupt? Corruption in the Indian judiciary takes various forms ranging from bribery and favoritism to nepotism and political interference. The most common form of corruption in the judiciary is bribery, where judges are allegedly bribed to deliver favorable judgments. This undermines the very foundation of justice and erodes public trust in the judiciary. Moreover, there have been instances where judges have been accused of favoritism and nepotism, where they have allegedly shown bias towards certain individuals or parties based on personal relationships or affiliations. Another form of corruption takes place during the allotment of cases or in the formation of benches. Dear friends, moving further, now I would like to put a light upon corruption in the Indian judiciary. Our judicial system has been the nation's moral conscience, speaking truth to political power, upholding the rights of citizens, mediating center-state conflicts, providing justice to the rich and poor alike, and on several momentous occasions saving democracy itself. Despite its achievements, a gap between the ideal and reality has been becoming clear over the years. The justice delivery is slow. The appointment of judges is mired in controversies. Disciplinary mechanisms scarcely work. Hierarchy rather than merit is preferred. Women are severely underrepresented, and constitutional matters often languish in the Supreme Court for years. If the Indian judiciary leaves corruption, India might have become a heaven. The Indian cinema has shown us numerous adaptations of rigged judicial verdicts. These depictions don't come merely from an imaginative mind, but clearly show us how things work under wraps. Our media keeps a close watch on the political participants, but they never point out the corruption in the judiciary or disclose the names of the corrupted judges, so the judiciary escapes the purview of the media. The judiciary is not held publicly accountable for major verdicts or prolonged court proceedings. For the first time in India, a sitting High Court judge, Honorable Justice C.S. Karnam, was sentenced to 6 months in prison for making allegations of corruption against Supreme Court judges in May 2017. The Supreme Court panel held him guilty of contempt of the court. In a more recent instances, the Central Bureau of Investigation made direct allegation of corruption against a sitting judge of the Lucknow bench of the Allahabad High Court when it booked Honorable Justice Narayan Shukla for receiving illegal gratification for allegedly favoring a medical college in a case. The Central Bureau of Investigation also named I.M. Kudasi, a retired judge of the Chhattisgarh High Court, and others in the cases. No one can question the court. There is no provision in the Constitution to register a case against a judge who has taken a bribe, since it is not feasible for a poor man to go and visit the Chief Justice of India and then register the FIR. The judges are hardly questioned about the nature of justice, as he or she does that they deem fit as per their legal knowledge. If an ordinary man questions the court, suddenly a contempt of court will be issued against him. While when 3 judges of Supreme Court asked Chief Justice why was not the contempt of court issued against them. Recently, there was a serious allegation of sexual harassment against the former Chief Justice of India, Shri Ranjan Gogoi, by a staff of the Supreme Court. The Supreme Court had taken a suo motu cognizance back, and then 3 bench judges, including the same accused Judge Ranjan Gogoi himself, conducted a judicial inquiry and closed the inquiry with the report that he was innocent. With this kind of autocracy, what kind of message these judges can give to society? Instances of corruption and bribery in the lower rungs of the judiciary keep getting reported regularly from across the country, which only add to an overall negative narrative against the judiciary. For example, in April 2018, 3 judges of lower courts in Telangana were arrested for possessing assets disproportionate to their known sources of income. Similarly, in Gujarat, 2 judges of the lower judiciary were arrested for allegedly taking money to settle cases during their posting at Vapi Court in 2014. In January 2018, 4 sitting Supreme Court judges held a news conference to highlight alleged rot that they claimed had set in the judiciary. Dear friends, moving further, now we will discuss the very crucial part of this module, that is causes of corruption in judiciary. Dear friends, various factors are responsible for the increasing corruption in the judiciary. Corruption in the judiciary can arise from a variety of factors, including Lack of transparency. One of the major factors contributing to corruption in the Indian judiciary is the lack of transparency and accountability. The opaque nature of judicial appointments and promotions has often led to allegations of favoritism and nepotism. The process of appointing judges to higher courts such as Supreme Court and High Courts has been a subject of controversy, with allegations of political interference and lack of merit-based selection. This has also raised questions about the independence and impartiality of the judiciary. Limited access to judicial processes and decisions can create opportunities for corruption, backlog of cases. For 1.7 billion people in India, there are 31 judges in the Supreme Court and 1079 in High Courts. There are never more than 600 judges in the High Court appointed at any point. As of April 2017, there were 430 posts of judges and additional judges lying vacant in High Courts and 5,000 posts vacant in the district level and lower. For 2017 and 18, the union budget allocated a meager amount of 1,744 crore to the judiciary, about 0.4% of the total budget. Indian judiciary is facing an institutional crisis on account of the most ferocious attack ever on the judiciary by the executive. Next one is political influence. Dear friends, interference from political entities can undermine judicial independence and integrity. Lack of effective mechanism. The issue of corruption in the Indian judiciary has also been exhibited by the lack of effective mechanism for addressing complaints against judges. The existing mechanism for investigating allegations of corruption against judges, such as the impeachment process, is cumbersome and often ineffective. This has created a culture of impunity where judges feel insulated from accountability for their actions. Low salaries for judges and court staff may lead them to accept bribes to supplement their income. Insufficient checks and balances can allow unethical behavior to go unchecked. Next is complex legal system. Overly complicated laws and procedures can create loopholes for corrupt practices. Pressure from external parties, lawyers, businesses and interest groups may exert undue influence on judicial decision. Further, lack of accountability. Without strong mechanism to hold judges accountable for misconduct, corruption can flourish. Dear friends, moving further, it is pertinent to know about regulatory mechanism to combat corruption in the judiciary. Judicial conduct and its regulation have been long-standing concerns in India. In 2010, former Union Law Minister swore an affidavit stating that 8 of the last 16 Chief Justices of India had been corrupt. Allegations of corruption and misconduct have only increased since then. 4 of 5 most recent Chief Justice, Justice Kehar, Justice Mishra, Justice Gogoi and Justice Ramna, have faced serious allegations of corruption or misconduct. Disappointingly, however, neither the judiciary nor parliament has been able to establish robust regulatory regimes to address the growing concerns of judicial corruption and misconduct. On the contrary, the judiciary has succeeded in evading external scrutiny, painting the reforms aimed at establishing an arm's-length regulatory institution as a threat to judicial independence. As a result, judges in India continue to be regulated through in-house mechanisms. These mechanisms grew out of need to prevent external influence from creeping into judicial processes. For example, They prevent external forces from influencing the judiciary under the pretext of regulating judges, as the in-house mechanism are exclusively administered by senior judges. They raise some peculiar challenges. Dear friends, first let us see how the judiciary and in-house regulatory regimes are structured and administered. The in-house mechanisms, their administrative autonomy has allowed the high courts to establish in-house mechanisms to deal with judicial conduct regulation. Every high court in India has an in-house vigilance cell headed by a senior district judge to monitor and facilitate disciplinary investigations against judges and court officials. The vigilance cells are institutionally and administratively a part of their respective high court. The remit of vigilance cells includes the judges and staff of subordinate courts, as well as the staff of the high court itself. The vigilance cells mostly work under the supervision of the High Court Chief Justice. For the higher judiciary, that is, for the High Court and Supreme Court judges, a constitutional removal procedure does exist as an ultimate censor, but it is rigid and long-winded. For this reason, the Supreme Court had to develop an in-house oversight mechanism that operates through judicial rulings, effectively regulating the judiciary by precedent rather than through policy. This is the mechanism through which complaints of misconduct or corruption are handled. The in-house procedure for the higher judiciary is administered by the Chief Justice of India. Moving further, dear friends, there are key concerns and challenges of the in-house mechanism. Let's have a look. The in-house mechanisms that govern the judiciary at every level have been criticized as non-representative, opaque, informal, and ineffective. Furthermore, these mechanisms have implications for individual and internal judicial independence, implications that have only recently been examined. While it is true that involving senior judges in judicial regulation may help to strengthen the institutional independence of the judiciary, their dominant position could also undermine individual and internal independence. This is particularly true where the decisions of senior judges are not subject to review or external scrutiny. Dear students, the next is the way forward to combat corruption in judiciary. Regulations governing judicial conduct must adhere to international standards, such as the Bangalore Principle of Judicial Conduct 2002, and be unbiased and independent. Consequently, it is necessary to create arm's-length entities with sufficient representation from all stakeholders to institutionalize India's regulatory system. Judicial hierarchy, wide regulatory systems should include lay people, judges, civil society representatives, and members of the bar. Such regulatory regimes need to be based on a thorough legal framework that mandates the impartial, consistent, and fair implementation of regulatory rules. If the disciplinary procedure is abused, senior judges who have supervisory or disciplinary authority should also answer for it. Disciplinary authorities misuse their authority far too frequently, yet there are no strong review or appeal processes to hear cases involving judges who have been subjected to unwarranted disciplinary actions. The disciplinary rulings of a high court can only be reviewed by the relevant high court or the Supreme Court. The judicial officers must therefore appeal a negative disciplinary decision to the same high court. The high court's judicial, disciplinary, and administrative powers are improperly combined, endangering the independence of individual judges as well as the court as a whole. Individual and internal judicial independence should be adequately emphasized from a regulatory perspective. Judges facing the disciplinary process must have minimum safeguards of fair trial and due process, and they should be shielded from false and vexatious complaints. Likewise, the judiciary ought to have robust internal mechanism to consider the representation of the individual judges in matters of deployment, appraisal, promotion, retirement, and removal. Judges should also have whistleblower protection to expose irregularities, corruption, and abuse of power within the judiciary. Unfortunately, most of these judicial regulations measures are lacking in India. India's in-house regulatory regimes in their present avatar fail to uphold judicial independence and effectively enforce judicial accountability. The senior judiciary and union and state legislatures should work together to reform regulatory regimes. The reform should sufficiently safeguard individual and internal judicial independence and adequately emphasize judicial accountability needs. Likewise, the regulatory regimes ought to function transparently and openly. Dear students, now I would like to conclude today's talk by saying that corruption in our society is like a cancer, which if not detected soon within the time, it will surely spread its magnificence among the polity of democracy. Corruption in Indian judiciary is a deep-rooted issue that requires urgent attention. Addressing this issue is crucial for upholding the rule of law and ensuring that justice is accessible to all. It requires a concerted effort from all stakeholders, the judiciary, government, civil society, and citizens to root out corruption and restore public trust in judicial system. Only then the judiciary can truly fulfill its role as a guardian of justice in India. So friends, with this we will end today's talk. Thank you so much. We'll see you in the next module. Thank you very much.